Good day, everyone. This is Arugu Speaks on Arugu Insights. Today, we'll talk about something very dear to my heart, and that is the Admiralty Jurisdiction in Nigeria. By way of introduction, the maritime endowment of Nigeria begins with our exceptional geography. Even our neighbors and our enemies agree with that Nigeria is really blessed as a country and as a nation. As a country, Nigeria possesses an approximate 853-kilometer coastline stretching from Lagos in the west to Calabar in the east, facing the Atlantic Ocean along the Gulf of Guinea. Unique and strategic resource. This coastline is complemented by an exclusive economic zone, EEZ, that is approximately 213 square kilometers or 82,240 nautical miles. This is larger than the land area of many nations here in Africa, and this is rich in living and non-living marine resources, including fisheries, oil and gas fields, and potential sites for offshore renewable energy. The inland waterway systems form another major pillar of this maritime endowment. Nigeria has about 8,600 kilometers of navigable rivers, creeks, and lagoons. However, this estimate is from other international organizations. However, newer reports, the Nigerian Inland Waterways Authorities reports that a broader total of about 10,000 kilometers of potential waterways across the country, with only around 3,000 to 3,800 kilometers currently classified as fully navigable year-round due to seasonal variations, sedimentation, and infrastructure limitations. These waterways connect 28 of Nigeria's 36 states and link to neighboring countries like Benin Republic, Cameroon, Chad, and Niger, supporting bulk cargo, fisheries, and regional trade. I think by this point it is important to list some of the 10 major rivers in Nigeria, ranked primarily by length and significance. We all know the River Niger is the longest river in Nigeria, having approximately 1,170 kilometers. It passes two major dams in Nigeria, the Kenji and the Jeba dams. The second longest river in Nigeria is River Benue, its largest tributary to the Niger, joining the Niger at Lokoja. And then the third longest river in Nigeria is Kaduna River, housing the Shiroro Dam. And then the fourth is Gongola River, which is the main feeder to the River Benue. And then the fifth river, longest river in Nigeria, is River Cross or Cross River, forming part of the Cameroon border. And then you have Sokoto Rima system, housing the Goronyo Dam. I served in Sokoto, so I have an idea of where the Goronyo Dam is. And then you have Anambra River coming up next, and then Ogun River, which is vital for Lagos water supply. And then you have Osun River, culturally important in Yoruba land. And then you have the Hadija Jama systems, all of them feeding the Hadija Unguru wetlands. Together with their tributaries, they drain most of the nation and support agriculture, hydropower, navigation, and fisheries. These waterways connect the southern coastal region with the northern hinterland and offer a low-cost, environmentally friendly alternative for moving bulk cargo, agricultural produce, and passengers. Yet, all of these remain grossly underutilized. Nigeria occupies a pivotal position on global and regional shipping routes. Nigeria generates over 65% of the entire cargo throughput in West Africa, West and Central Africa, making her ports natural transshipment hubs for landlocked neighbors such as Niger, Chad, and parts of Mali. The recent completion of the Lekki deep sea port, one of the deepest in sub-Saharan Africa, further strengthens the advantage by accommodating the largest container vessels and reducing congestion at older ports. A robust, predictable, and economically realistic Admiralty jurisdiction is therefore not a luxury but a necessity. The entire edifice of modern Nigerian Admiralty law rests on two basic pieces of legislation: the Constitution and statutory pillars. Section 251, sub 1, sub G of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and the Admiralty Jurisdiction Act, number 30 of 1991, Cap A3, Laws of the Federation of Nigeria, 2004. By way of definition, what is Admiralty? Admiralty law in Nigeria is also known as maritime law, and Admiralty law governs all matters relating to shipping, navigation, commerce, marine commerce, collisions, salvage, towage, cargo claims, marine pollution, and the rights of seafarers. Exclusive jurisdiction over these matters is vested in the Federal High Court by virtue of Section 251 sub 1 sub G of the Constitution 1999. This jurisdiction covers both civil and criminal maritime issues, including proprietary claims such as ship ownership and mortgages, as well as general maritime claims involving damage to cargo, salvage reward, collisions, and pollution. Appeals from decisions of the Federal High Court proceed to the Court of Appeal and ultimately to the Supreme Court. The principal statute governing Admiralty jurisdiction in Nigeria is the Admiralty Jurisdiction Act 1991. In course of this lecture, we'll be talking about AJA. When we talk about AJA, we are making reference to the Admiralty Jurisdiction Act 1991. The AJA defines the scope of the Admiralty jurisdiction of the Federal High Court. The AJA lists the maritime claims that may be enforced, provides for the arrest of ships and sister ships, establishes maritime lanes, and regulates the limitation of liability. Complementing the AJA is the Merchant Shipping Act, or MSA 2007 Cap M11, Laws of the Federation 2004. The MSA serves as the primary legislation for shipping operations, ship registration, safety standards, collision regulation, salvage, wreck removal, and the liability for oil pollution. Another piece of legislation that comes next is the Nigerian Maritime Administration and Safety Agency Act of 2007. This piece of legislation established the Nigerian Maritime Administration and Safety Agency, NIMASA, as the apex regulatory authority responsible for maritime safety, security, ship registration, pollution prevention, and enforcement of cabotage regulations. In course of the semester, we will talk about all of these things we're talking about: ship registration, pollution prevention, and then cabotage regulations. Domestic coastal and inland shipping is strictly regulated by the Coastal and Inland Shipping Cabotage Act of 2003. The Cabotage Act reserves such trade for vessels that are wholly owned and crewed by Nigerian citizens, subject only to limited ministerial waivers. Carriage of goods by sea fall under two legal regimes: the Carriage of Goods by Sea, COGSA 2004, which incorporate the Hague Rules for outward shipments, and the United Nations Convention for the Carriage of Goods by Sea, the Hamburg Rules Act of 2005, which applies the Hamburg Rules to both inward and outward shipments. Admiralty proceedings in Nigeria are designed to be swift and specialized. They are sui generis, and since 2023, they have been governed by the Admiralty Jurisdiction Procedure Rules 2023 that replace the AJPR, or the Admiralty Jurisdiction Procedure Rules 2011, and the AJPR 2023 introduced significant modernizations. We're going to talk about all of these in our later lectures, and some of these modernizations include provision for electronic filing, virtual hearing, and even the courts are willing to sit on public holidays for urgent arrest applications, dedicated Admiralty jurisdiction in the Federal High Court, and much stricter timelines. Vessel arrests are obtained ex parte through a writ of summons supported by an affidavit, with the arrest order valid for 6 months and renewable. The Admiralty Marshal now has expanded duties that include custody, preservation, valuation, and sale of arrested vessels. Caveats against arrest or release are restricted and require the caveator to post security within 14 days. Claims for wrongful arrest face a higher threshold, requiring proof of bad faith or gross negligence. If adequate security is not provided, judicial sale of the vessel may proceed after 60 days. Arbitration awards and foreign judgments are enforceable by originating motions. Where the Admiralty Jurisdiction Procedure Rules are silent, the AJPR is silent, the Federal High Court Civil Procedure Rules 2019 apply subsidiarily. Nigeria has incorporated several major international maritime conventions into domestic law, and these include the Hague Visby and the Hamburg Rules on Carriage of Goods, the 1972 Collision Regulations called Reg, SOLAS 1974 and MAPOL 73 and 78 Conventions on Safety and Pollution, the 1992 Civil Liability Convention, the 1996 and 1997, the 1976 and 1996 Limitation of Liability for Maritime Claims Convention, the 1989 Salvage Convention, the 1974 Athens Convention on Passenger Liability, and the 1958 New York Convention on Arbitration, now governed domestically by the Arbitration and Mediation Act 2023. Nigeria has also ratified the 1982 United Nations Convention on the Law of the Sea, which underpins maritime zones. The Nairobi International Convention on Removal of Wrecks 2007 has been signed but not yet fully domesticated. As of 2025, the most notable developments include the full implementation of the AJPR 2023, which have greatly enhanced efficiency through digitalization and reduced delays in arrests and judicial sales. NIMASA has also commenced disbursement of the long-delayed Cabotage Vessel Financing Fund to strengthen indigenous shipping capacity. Important judicial pronouncement such as the Supreme Court decision in GP Industries and MV Quota Menis that reaffirmed the unique nature of Admiralty proceedings, and the various Court of Appeal rulings on caveats and joinder of actions continue to refine Admiralty practice in Nigeria. In essence, the Admiralty legal framework in Nigeria combines comprehensive domestic legislation, modern and specialized procedural rules, and selective adoption of leading international conventions to create a predictable, efficient, and economically sensible systems for the resolution of maritime disputes. There is this distinction drawn between Admiralty law, which is more about the procedure and the jurisdiction of the Old English Admiralty Court, and then maritime law, which talks about the substantive lex maritima and has been authoritatively declared to be of no practical relevance or importance in Nigeria. In MV Arabella and the Nigerian Agricultural Insurance Corporation, a 2008 decision, Justice Nikitobi stated that in modern Nigerian jurisprudence, the expressions Admiralty law and maritime law are used interchangeably, thereby aligning Nigeria with jurisdictions such as Australia and South Africa, where the historical distinction has been abolished. So, when you talk about the difference between maritime law and Admiralty law in Nigeria, that distinction is just academic in nature and of no value as we talk today. Let us look at the word jurisdiction. What then is jurisdiction? According to experts, jurisdiction is the lifeblood of adjudication. Without jurisdiction, any decision, no matter how beautifully conducted, no matter how erudite, everything is in nullity ab initio. The locus classicus on the meaning and conditions for valid exercise of jurisdiction in Nigeria is the decision of the Nigerian Supreme Court in Madukolu and others, and Nkemdilim in 1962 decision of the Nigerian Supreme Court. In that decision, Baramian FJ, delivering the judgment of the Supreme Court, held, and I quote him verbatim, "A court is competent and has jurisdiction when 1. It is properly constituted as regards the numbers and the qualification of the members of the bench, and no member is disqualified for one reason or another. 2, the subject matter of the case is within its jurisdiction and there's no feature in the case which prevents the court from exercising its jurisdiction. And 3, the case comes before the court initiated by due process of law and upon fulfillment of any condition precedent to the exercise of jurisdiction. End of quote. This trinity of conditions has been cited with approval in literally thousands of subsequent decisions and remain the acid test for jurisdiction in every Nigerian court, including the Federal High Court exercising Admiralty Jurisdiction in Nigeria. The Supreme Court has consistently applied and expanded the decision in Madukolu and others, and Nkemdilim in Admiralty and other contexts. Let us look at in Scam Consult Nigeria Limited and Uke, a decision of the Nigerian Supreme Court in 1981. Bello JSC, as he then was, reaffirmed that jurisdiction is radical and fundamental. Once absent, the entire proceedings are a nullity, however well conducted. The Supreme Court described jurisdiction as the limits imposed on the power of the court by the Constitution, the statute that created it, or any other law. In Western Steel Works Limited and Iron and Steel Workers Union, a 1987 decision of the Nigerian Supreme Court, Oputa JSC described jurisdiction as the very foundation on which the court stands. In Mobile Producing Nigeria Unlimited and Lagos State Environmental Protection Agency, a 2002 decision of the Nigerian Supreme Court, the Supreme Court emphasized that where jurisdiction is donated by the Constitution, as in 251 sub 1 sub G, no statute, no rule of court, or private agreement can validly take it away. More recently, in Dangote Cement PLC and Onyechere, Okoro JSC restated the Madukolu conditions verbatim and added that any defect in competence is fatal, for the proceedings are a nullity, however well conducted and decided. So many Nigerian scholars have added their voice in the definition of jurisdiction. Ben Obi, in his famous book, The Nigerian Law of Evidence and Civil Procedure, defined jurisdiction as the authority which a court has to decide matters that are litigated before it, or to take cognizance of matters presented in a formal way for its decision. Professor I.O. Smith, in his book, Nigerian Law of Admiralty, calls jurisdiction as the very foundation upon which the judicial process rests, a threshold issue. Fidelis Nwadialo famously said in its seminal work, Civil Procedure in Nigeria, that jurisdiction is the blood that gives life to the actions of the court. No blood, no life. In the specific context of Admiralty, the Supreme Court has repeatedly held that the jurisdiction conferred by Section 251 sub 1 sub G of the 1999 Constitution and Section 1 and 3 of the AJ is exclusive, statutory, and inalienable. In Texaco Overseas Petroleum and Pedma Nigeria Limited, a 2002 decision of the Supreme Court, Ayola JSC declared that the Admiralty jurisdiction of the Federal High Court is special, exclusive, and cannot be shared with any other court or tribunal in Nigeria. In Nigerian National Petroleum Corporation and SLB Consortium Limited, a 2021 decision of the Nigerian Supreme Court, the Supreme Court again applied the principles espoused in Madukolu and Nkemdilim and held that once a claim possesses a maritime flavor or connection with shipping or navigation, only the Federal High Court is competent to entertain it. Let us now go to something that is very key. What then is the scope of the Admiralty jurisdiction of the Federal High Court? The scope of the Admiralty jurisdiction is deliberately wide. Section 1 sub 1 AJ lists 18 categories of maritime claims. Section 251 sub G of the Constitution speaks of matters relating to Admiralty, shipping and navigation. The Admiralty jurisdiction of the Federal High Court in Nigeria is exclusively conferred by Section 251 sub 1 sub G of the Constitution of the Federal Republic of Nigeria 1999 and interpreted and fleshed out by the AJ in 1991. Over the past 3 decades, the Supreme Court and the Court of Appeal have progressively defined, narrowed, and quite recently begun to expand the boundaries of this jurisdiction through a series of landmark decisions. Let us consider some of these decisions. The foundational limitation when you talk about cargo link or tackle-to-tackle test that was laid in the famous decision in Petro Jessica Enterprises Limited and Leventis Technical Company Limited in 1992 decision of the Nigerian Supreme Court. In that case, what actually happened? Goods were carried by sea from overseas to Lagos, discharged from the ship, placed in a warehouse, and subsequently damaged by rain due to the negligence of the terminal operator. In that case, the plaintiff sued in the Federal High Court invoking its Admiralty jurisdiction. The Supreme Court, reading the lead judgment, Caribbean-wide JSC held, and I quote, "The Admiralty jurisdiction of the Federal High Court in respect of carriage of goods by sea is only in respect of causes of action that arise while the goods are on board the ship under the tackle of the ship. Once the goods are completely discharged from the ship and delivered to the consignee or his agent, the contract of carriage by sea has been fully performed. Its function and any further dispute is a matter of simple contract or tort outside Admiralty jurisdiction." The Supreme Court reasoned in that case that the maritime flavor of the contract ends the moment the ship's tackle, the cranes and the slings, the hooks, etc. is detached from the cargo at the port of discharge. Hence the phrase tackle to tackle, which has the following core elements. The cause of action must arise while the cargo is physically on board the vessel or under the ship's tackle. Once cargo is fully discharged and delivered, even if still within the port or customs warehouse, any subsequent damage, short landing, misdelivery, or delayed claims loses its maritime flavor or character. Such post-discharge claims become ordinary claims in contract or tort triable by the state high courts. I disagree with this reasoning, but that is what the Supreme Court stated in the tackle-to-tackle principle it laid in Petrojessica. But let's move forward and see what happened later on. It is noteworthy that in African Petroleum Limited and Owuduni, an earlier Court of Appeal decision laid the intellectual foundation for the decision in Petrojessica. This restrictive approach was reinforced in Texaco Overseas Nigeria Petroleum Company Limited and PIDMA Nigeria Limited, the 2002 decision, and in Pesas Multi-Dynamics Limited and MV Dancing Sisters, a 2012 decision of the Supreme Court, where the Supreme Court ruled that claims for demurrage, unpaid hire, or damage arising after discharge of cargo no longer retain the maritime character required for the Federal High Court Admiralty jurisdiction, even if the original contract was a contract of carriage of goods by sea. A broader and more permissive view of in-rem action was, however, affirmed in Sona Nigeria Limited and MV Arabella, a 2000 decision of the Nigerian Supreme Court, and then later in GP Industries Nigeria Limited and MV Cotton Menis, a 2025 decision of the Nigerian Supreme Court. These decisions confirm that actions in rem against a ship for maritime lands, collision, salvage, etc. are sui generis. That means they are of a peculiar kind and they fall squarely within the exclusive Federal High Court jurisdiction nationwide and are governed primarily by the AJA and the AJPR 2023, overriding conflicting provisions of the Sheriff and Civil Process Act or General Federal High Court Civil Procedure Rules. The Supreme Court has also clarified the limits of ship-related contracts. In TSKJ Nigeria Limited and Autochem Nigeria Limited, a 2018 decision of the Supreme Court held that not every contract involving a vessel qualifies as an admiralty claim. A simple hire or supply agreement that do not give rise to a statutory maritime land fall outside section 251 sub 1 sub G of the Constitution of the Federal Republic of Nigeria 1999 unless specifically listed in section 2 sub 3 of the AJ. More recent judgments show a gradual departure from the rigid cargo link doctrine to accommodate modern multimodal transport. In Glenyork Nigeria Limited and Panalpina Nigeria Limited, a 2025 decision, the Supreme Court ruled that where sea and land carriage form part of a continuous contract, a single continuous contract, example, through bills of lading, covering both legs, the entire claim remains within the Federal High Court Admiralty jurisdiction, making a significant liberalization. The Supreme Court has consistently given a broad and liberal interpretation. In Chevron Nigeria Limited and Mobile Producing Nigeria Limited, disputes arising from offshore supply and service contracts were held to fall squarely within the Admiralty jurisdiction. Similarly, in Nigerian Westminster Dredging and Marine Limited and Nigerian Ports Authority, a 2018 decision, dredging contracts connected with navigation were brought within the fold of the Admiralty jurisdiction of the Federal High Court. It is noteworthy that jurisdictional boundaries have been redrawn in employment-related maritime claims. In the vessel empty some purpose and Amajet Singh Bains, a 2020 decision, and subsequent cases, our courts have held that seafarer wage disputes, although listed under the AJA, now fall under the exclusive jurisdiction of the National Industrial Court by virtue of Section 254C of our Constitution, representing the Third Alteration Act, thereby carving out a major category of traditional admiralty claims. Taken together, these decisions reveal an evolving jurisprudence, an initially narrow scope in the 1990s and 2000s, a robust protection of in-rem procedure, and a cautious but noticeable expansion in the 2020s to reflect contemporary global shipping practices while still maintaining clear constitutional and statutory boundaries. The most significant jurisdictional crisis in the history of Nigerian admiralty law occurred between 1979 and 1999 and centered on an apparent head-on collision between constitutional and statutory provisions. Section 236 of the 1979 Constitution, which conferred on every state high court unlimited jurisdiction to hear and determine any civil proceedings in which the existence or extent of a legal right is in issue, and Section 7, Sub 1, Sub D, and Section 8 of the Federal High Court 1973. Later, Section 7, Sub 1, Sub G of the Federal High Court Act 134, Laws of the Federation 1990, which gave the Federal High Court, then the Federal Revenue Court, exclusive jurisdiction in admiralty matters. This conflict produced over 2 decades of contradictory decisions, forum shopping, and legal uncertainty that seriously undermined the development of a coherent body of admiralty law in Nigeria. Let us, by way of trying to break down the years, look at the phase 1. From 1979 to 1992, the state high courts assert unlimited jurisdiction and hear admiralty cases. Immediately after the 1979 Constitution came into force on 1st October 1979, many state high courts, particularly those in Lagos, Rivers, and Cross River states, held that Section 236 of the Constitution of Nigeria 1999 conferred the regional unlimited jurisdiction on them, and that the exclusive Admiralty jurisdiction earlier given to the Federal Revenue Court or the Federal High Court by the 1973 Act has been impliedly repealed or overridden by the Constitution of Nigeria 1979. Key decisions in this school of thought include the Savannah Bank of Nigeria Limited and Pan-Atlantic Shipping and Transport Agencies Limited, decided in 1989 by the Supreme Court. Oputa, Karibi White, and Onamani sat on the matter, and other justices of the Supreme Court. In that case, the court held that under the 1979 Constitution, the state high courts had concurrent jurisdiction with the Federal High Court in Admiralty matters because Section 236 of the 1979 Constitution was clear and later in time, and a superior law that conferred unlimited jurisdiction on the state high courts. The Supreme Court reasoned that the 1973 Federal High Court Act could not limit the plenary jurisdiction granted by the Constitution of the Federal Republic of Nigeria 1979. This decision effectively opened the floodgates. Lagos and Rivers State High Courts became major centers for Admiralty litigation, and a large body of maritime case law developed outside the Federal High Court. American International Insurance Company and CK Traders Limited, Nigerian Ports Authority, and Pogio Nigeria Limited decided during the tail end of the Savannah Bank era permitted the state high courts to grant wherever injunctions in Admiralty-related personal injury claim on the high sea. While primarily on remedies, it followed the concurrent jurisdiction logic and has been disapproved in light of the exclusive federal jurisdiction now mandated. The Supreme Court, in Trade Bank PLC and Benelux Nigeria Limited, the 2003 decision, although decided shortly after the 1999 Constitution, relied on Savannah Bank with approval in a banking dispute intertwined with shipping finance, suggesting residual concurrent jurisdiction. The Supreme Court again in Texaco and Pedmer explicitly overruled such lingering applications, confining all shipping-related financial claims to the Federal High Court. All these decisions followed Savannah Bank and affirmed concurrent jurisdiction. The Phase 2, the 1992 to 1999, at this point there was a legislative intervention and renewed conflict. In direct response to the decision of the Supreme Court in Savannah Bank, the military government at that time promulgated the Constitution Suspension and Modification Decree number 107 of 1993, which included Section 230 sub 1 sub G of the Constitution as amended. The provision gave the Federal High Court exclusive jurisdiction in Admiralty. The subsection was later reenacted verbatim as the current Section 251 sub 1 sub G of the Constitution of the Federal Republic of Nigeria 1999. Even with this amendment, some courts continue to follow Savannah Bank on the ground that the decree was merely legislative and could not override interpretations of the Constitution of the Federal Republic of Nigeria 1999 by the Supreme Court. The conflict, therefore, persisted. Let's move to phase 2, 1999 to 2002. The Supreme Court reverses herself and resolves the conflict. The definitive resolution came with 2 landmark decisions of the Supreme Court under the 1999 Constitution. The Nigerian National Petroleum Corporation and SLB Consortium Limited, the 2002 decision, a 7-man member panel of the Supreme Court having Ogundare, Ayola, Ejinwumi, Katsinalu, Kalgo, Edozie, and Waifo unanimously overruled Savannah Bank and held that Section 251 sub 1 sub G of the Constitution of the Federal Republic of Nigeria is clear, mandatory, and confers exclusive jurisdiction on the Federal High Court in Admiralty matters. The earlier decision in Savannah Bank was reached by incuriam because the Supreme Court failed to consider the full implications of the legislative response to the jurisdictional crisis. Any decision of a state high court in Admiralty matters after the coming into force of Section 251 sub 1 sub G of the Constitution is a nullity for want of jurisdiction. In Texaco overseas Nigeria Petroleum Unlimited and Pedman Nigeria Limited, a 2002 decision, the court decided the same case, decided the same year by another full panel. The Supreme Court reaffirmed the exclusive nature of the jurisdiction of the Federal High Court and held that the provision is not limited to actions against federal agencies, but covers all Admiralty causes and matters. The 2002 decisions finally and authoritatively settled the law. Savannah Bank and all cases that followed it under the 1979 constitutional regime were outruled. The Federal High Court has had exclusive original jurisdiction in all civil admiralty matters since 17 November 1993, the date Decree 107 of 1993 came in force, and certainly since 29 May 1999 under the Constitution of the Federal Republic of Nigeria. All judgments delivered by the state high courts in admiralty matters after these dates are nullities. Subsequent affirmations such as in NDIC and Okem Enterprises, a 2004 decision of the Supreme Court, have reinforced that any post-1993 admiralty judgment from a state high court is void. For current practice, reference should be made to post-2002 authorities emphasizing the maritime flavor test for exclusivity. The current position, the post-2002. The law is now beyond doubt. Only the Federal High Court can entertain civil admiralty causes or matters in Nigeria. Look at section 251, sub 1, sub G of the Constitution and section 1AJ 1991. The state high courts have no jurisdiction whatsoever, even if the claim is framed in simple contract or tort, once it possesses a maritime flavor. The Supreme Court has repeatedly reaffirmed this in subsequent cases such as Chevron Nigeria Limited and Mobile Producing Unlimited, a 2015 decision, and Nigerian Westminster Dredging and MPA, a 2018 decision. Thus, after more than 2 decades of uncertainty, the conflict was conclusively resolved in 2002 by the courageous and pragmatic overruling of its earlier decision in Savannah Bank by the Nigerian Supreme Court. The exclusive Admiralty jurisdiction of the Federal High Court is now one of the most firmly entrenched principles in Nigerian jurisdictional law. The Nigerian Admiralty jurisdiction, built on the unshakable foundations of section 251, sub 1, sub G of the Constitution of the Federal Republic of Nigeria 1999, and the detailed statutory framework of the AJ, and interpreted through the prisms of Madukolu and Nkemdilim, as its progeny is exclusive, expansive, procedurally sophisticated, and fiercely protective of national interests. As Nigeria pursues its blue economy ambitions, the continual judicial fidelity to these principles will determine whether Nigeria remains an attractive yet sovereign maritime jurisdiction in the Comity of Nations. Thank you for listening. I welcome your questions and your comments. You are watching this video perhaps, or because you stumbled on this video online, or you have graciously subscribed to our channel on YouTube, or you are following us on Facebook, on Twitter, now X, Instagram, and TikTok. If you have not subscribed or you're not following us, please do so. Feel free to share videos, make your comments, ask your questions. Our team is available online 24/7 to bring actions, to bring answers immediately. We thank you for listening. Appreciated. Unshakable foundations of section 251, sub 1, sub G of the Constitution of the Federal Republic of Nigeria 1999, and the detailed statutory framework of the AJ, and interpreted through the prisms of Madukolu and Nkemdilim, as its progeny is exclusive, expansive, procedurally sophisticated, and fiercely protective of national interests. As Nigeria pursues its blue economy ambitions, the continual judicial fidelity to these principles will determine whether Nigeria remains an attractive yet sovereign maritime jurisdiction in the Comity of Nations. Thank you. You have listened to this video Perhaps because you stumbled on this video or because you have subscribed. If you have not subscribed to our channel, please do so. Subscribe to our YouTube channel on Arugu Insight. Follow our Facebook, our Twitter, now X, our TikTok, and Instagram handles on Arugu Insight. Feel free to share videos, like, and comment. We are doing this because of you. Thank you. We look forward to hearing from you.